Good morning. I'm Lisa Grennan. I'm the Family Program Manager for MWR, and so excited today to have Stacey Lott, Attorney Stacey Lott, with us. She does estate planning and elder law, and she's here in person. She's very excited to be back in person and to answer any questions you may have during. If you can help me in welcoming Stacey Lott.
Hello, everybody. I am so happy to be back in person because I don't mind doing the virtual ones with you. It's fun, but I like it because usually at the end of these, if people have questions they just don't feel comfortable raising their hands about, you can come see me after and I can try to help as much as I can in this limited amount of time we've got. So hopefully all of you got a handout, and if you didn't, just raise your hand and we can get you one if you need one. And this is the same one I use all the time, if you guys have ever been to my online ones or in the past year, because there are 5 questions that I get asked the most in my practice, or even just walking down the street talking to people I know, and these always kind of shoot off into different questions that people have. So I'm one of those speakers that doesn't mind if you raise your hand in the middle of it and want to ask a question, because I don't want you to forget what you wanted to ask. So as I start going, feel free to interrupt or raise your hand, and I'll answer your questions as we go. So the first section here is, what is probate? Because there are a lot of people out there that try to scare you about probate. Like, oh gosh, you have to avoid probate at all costs. Probate's the worst. Yeah, probate's kind of a pain because it is a court proceeding. You do have to pay quite a bit of money to lawyers to do it for you. It does take a little bit longer than regular distribution under maybe a trust or something like that. But probate is basically a court process by which your assets get from your name into whomever you want it to go to through a court proceeding. Because you know how anything that you own that's making money, like interest or something, they use your social security number to track that. But when you die, your social security number dies with you, right? So in order to transfer anything that's in your name to someone else's name, you either have to do something like a beneficiary, which you guys all know about, or sometimes people will add joint owners, which I don't always love. But if you don't do any of that, if there's no beneficiary, if there's no joint owner, then that asset would have to go through probate, right? So you hire an attorney to petition the probate court to appoint someone to be the personal representative or executor, it's called personal representative in Michigan, of your estate. And then that person will, if you have a will, because a will doesn't avoid probate. A will just tells the probate court how you want things to go. So if you have a will, the personal representative will just do what the will says. If you don't have a will, the state of Michigan has their own will made up for you, basically who your heirs are and where things will go. Probate basically just gets your assets from your name to whoever you want it to go to, or to your family members after you're gone. Some people don't care about probate. They're like, hey, I'll be gone. If my kids have to pay for it after I'm gone, who cares? I don't need to do anything more now. Let's just let them deal with it, which is fine. It just is a little bit more work for them. The other thing about probate is it's not private, it's public record. So if anybody opens a probate case for your estate, anyone, like I could walk in, or any of you could walk into the probate court and ask to see a file, and you're allowed to see it. It's public record. So it's not private, whereas if you did a trust, nobody has the right to see that unless it's contested in court or something like that. So that explains probate. I think the most important thing I want to reiterate about probate is people will go see an attorney, get a will done, and think they're done. And a will does not avoid probate, okay? A will just tells the probate court how to distribute things, all right? Any questions about probate right now off the top? Well, it just depends on the company or the, if it's like a retirement account, for instance, or, so it depends on the company or the entity. I'm not sure about the federal government, but I think, my husband was a teacher, and yes, it automatically, your spouse has to sign off a waiver to let somebody else be the beneficiary. I'm not sure about the federal government. I'm guessing probably. So it just really depends on the entity that you have it through. That's a good question. Anybody else? No? Okay. So the next part is, what's the difference between a will and a trust? And we kind of touched on that, all right? A will does absolutely explain who you want to be in charge and where you want things to go, but it doesn't avoid the probate process, and it can't do some of the things that you can do in a trust. Okay, so for instance, I'll explain what a trust is. A trust does the same thing. You pick someone to be the trustee, or you can have successors if that person can't do it. You're your own trustee while you're alive. It's only after you're gone that somebody else would step in, and that trustee is the person that would manage the assets, distribute everything, sell your house, do all that kind of stuff to liquidate everything, pay all your bills, and then distribute it how you want it to go, okay? The cool thing about a trust is you can name, for instance, minors in there. Like if you have a specific grandchild that helps you with everything and you want to make sure they get this little percentage, at a certain age, maybe they're 18 now, but you want to wait till they're 25 till they get it, you can put that in there and the trustee can hold that in trust till that person's old enough. Or if you have minor children, I have 20-year-old twins who I don't feel are responsible enough yet to be able to handle any life insurance they might inherit or anything like that. I think my daughter would do a great job, my son, probably not. So I can put in there that they get a third at 25, a third at 30, and a third at 35, but the trustee can use it for things they need in between, like their health, their education, maintenance, and support. But my trustee has complete discretion. So if my son says, hey, my car died, I need a brand new Mustang, she can say, no, but let's repair your car. Let's fix this. She would have discretion to be able to do that. So there are things that the trustee can do to help the person, but they don't get cash in their hot little hands to blow however they want until they're certain ages. And those are things that you can do in a trust that is not necessarily something that you would do in a will because it's going through probate, right? So it's kind of neat. The other thing about a trust is you can make different kinds of trusts to protect things. So for instance, if you have a special needs child and you want to make a trust to protect their assets if they inherit something for you so that they could keep their Social Security benefits or they could keep their Medicaid benefits, we can do a trust to protect assets that way for those types of people. We can also do trusts like in second or third or fourth marriage situations where you want some of your assets to go to your kids, but you want a little bit to go to your spouse if something happens to you because your spouse is not your kid's parent. There are ways we can set that up in trusts too, that it's a little more nuanced that you can't do as easily in a will, okay? So trusts can do a lot of neat things. I sometimes call it reaching up from the grave and controlling things after you're gone because you can spell out at what ages and at what, for what reasons people get assets from your trust, okay? And a trust, the hardest part for somebody, I think, when they create a trust is doing what's called funding the trust. And I don't know if you guys have heard of that before, but basically that's when you go see your lawyer, they write up a trust for you, and you're like, great, we have our trust now, we're all done. And you're not, because your lawyer should give you this homework sheet that tells you how to make sure your trust is either the owner or the beneficiary of most of your assets. So you might have to go to the credit union and make your trust the beneficiary of your credit union accounts, or go to your bank and make the trust the owner of your bank accounts. It just depends on the entity we're looking at. You might need to make your trust the beneficiary of your life insurance policies. So we have to make sure your trust is named as the owner or the beneficiary of certain things so that it all goes into one pot after you're gone and is distributed the way the trust says, okay? So there's something to making sure that you understand it's not just, hey, let's go get it written up. There's a little bit of work you have to do after it's done. But then once you do that, you're done and it's good and it works, which is nice. Back in the day, people would do trusts to avoid inheritance tax. Like my dad died in 1997. The inheritance tax limit was $600,000. So if you had a $750,000 life insurance policy, you were over the inheritance tax when you died, right? Now your spouse can inherit and there's no problem. They don't have an issue with that. It's only if it went down to kids. Well, in 2024, if you go to page 2, it says the inheritance tax limit this year is $13.61 million. So there's very few people I know that have $13.61 million, and that's per person. So the couples, you're looking at, $27 million you can have and not have to worry about inheritance tax. So I think we're okay there. Most of us anyway. If you're not, then you can afford probate and taxes and everything you need to deal with. But But we don't really have to worry about doing trusts to avoid inheritance tax anymore because the inheritance tax limit just keeps going up and up. I mean, it was 12 point, some of you might have the old one that says 2023 was 12 point something. I mean, look how much it goes up each year. It's crazy. So it's not something we really have to worry about too much. So does anyone else have any questions about the difference between a will and a trust or trusts at all right now? No? Yes, sir. For inheritance tax, so a will or a trust, you're not going to have to worry about anything unless you have, $13 million. But with a will, you have to pay fees and like assessments at the probate court where you don't have to do that through a trust, and you have to pay an attorney to go to court to do the probate for you if you have a will, where you might go to an attorney to like just kind of get your marching orders on how to do the trust, how to administer the trust. It's not quite as intensive, I think, as probate would be. So any other questions? Yes, sir. That's what most people do. Yeah, the question was, I have 3 children. If I wanted my oldest to be the trustee, is that allowed? And I said, yes, that's what most people do. Most people do name their children if they're responsible. You trust them, they're adults. Yeah, absolutely. No, they can still be a beneficiary too. Yeah, they can be both. So, for instance, for my mom's trust, my sister and I are the 2 beneficiaries, and I'm the trustee, and I'm still supposed to get 50%. It's what I do for a living, so it made sense to make me the trustee. But if I wasn't around, my sister is the contingent trustee, and she is also a 50% beneficiary. So most people do name their children if they're able to. Sometimes, people squabble about things. Obviously, families, that happens. And if you have a kid that can stand up and do exactly what the parents wanted, follow the rules, be able to tell their siblings, hey, just read it, this is what they wanted, then that's what most people do, is name their children, yeah. So not everybody has children, or they might have minor children, or they might have children they don't think would get along, or children that aren't responsible enough to handle this kind of thing, or just couldn't handle it, so that they have to figure out somebody else that could do it. Right now, my husband and I are primary, or the survivor of us, but if we aren't surviving, my best friend is my trustee until my kids, I feel, are responsible enough to handle it. They're close. They're right on the cusp. They're very close, but I'm not quite ready to hand that over to them yet. So any other questions? Yes, ma'am. Yeah, so basically, can you make your child, if you only have 1 child and 1 grandchild, you can make your child the trustee and the beneficiary, but if something happened to both of you, then that money would still go to the grandchild, yeah. It doesn't have to be the grandchild, it could be somebody else. Because if your child is gone, someone has to administer the money to your grandchild. Maybe, yeah, but whoever you want. It could be anybody you want, whoever you trust. Yeah, it could be anybody. So, but basically she was saying that, would you make the grandchild the trustee? And I said you could, or you could make anybody the trustee to get the money to the grandchild if is it your son? Is that, yeah. If your son is a daughter or son that you have? Son. If your son were gone, then you'd have to have somebody else to distribute the money to the grandchild, yes. You could write that, that could be in the trust, yeah, yeah. So she was basically saying, if my son and I were both killed in an automobile accident, could I write it that my grandson would be the trustee and the beneficiary? And yes, you absolutely can do that. They would be the contingent beneficiary and the contingent trustee. So yes, there was a question back there. Yep, yep. And the reason we do that is if, God forbid, something did happen to her, it's not going to, but if it did, you can put in there who would get it then, and instead of just making someone adding someone to your house or making someone beneficiary on everything, if something happens to her, then you have to then go through probate to get it to whomever else you'd want it to go to. So, yes, ma'am.
Stacey, so does it totally avoid probate if you have a trust versus if you have the will, you
Correct.
end up in probate?
Correct, because the trust doesn't have, after you're gone, you're gone, but the trust keeps going. The trust is its own entity, and it keeps going after you're gone. And you have successor trustees that jump into your shoes and keep the trust going after you're gone. So it has its own tax ID number after you're gone. You use your own social security number while you're alive, but after you're gone, we can get a tax ID number for the trust and it keeps going. Yes, ma'am. Correct. Yeah, so the question was, let's say someone has a will and they want their 3 children to get, a third equally of their will, right? But they forgot that they put one of their kids on a bank account, all right? Their big bank account, let's say. And so their kid is joint on the bank account. Technically, she said, they don't have to split that account 3 ways. The person that was on the account gets to keep it all. That's correct. So a will is trumped by a joint ownership or a beneficiary. So sometimes people, even trust, like if you don't put something in your trust, I'll give you an example. My mom's trust says everything goes to my sister and I, but I have a stepdad, okay? Instead of making the trust the beneficiary of her life insurance policy, she made my stepdad the beneficiary of her life insurance policy. So that trumps the trust. That goes directly to Larry, and everything else goes to my sister and I because she wanted something to go to him, So he's leaving his pension to her. So she's leaving this one life insurance policy to him. But everything else is in the trust and going to my sister and I. And sometimes we do it on purpose, but sometimes it's a mistake. And that daughter or son or whomever it is that's on that account, if they're not a good kid, they can keep all of it and not split it with their siblings. And that happens all the time. All the time. And people are like, well, the bank told me to put my kid on there, so it makes it easier. And they do it, and the banks and the credit unions will tell you that all the time. And they're giving you legal advice and not realizing that that kid that you're putting on the account might not be a good kid and might not want to split it with their siblings. And so be real careful about that, okay? Because that, yes, ma'am. Same thing. Same thing. The question was, what if you have 3 kids and only one is a beneficiary of an account? Same thing, that one kid that's the beneficiary. And some people do that for like funerals. Like they have a small life insurance policy, like a $10,000 policy, so they make their responsible kid the beneficiary of their life insurance policy because they know they're going to use that to pay for the funeral. That does happen a lot, but if that's not the case, if it's just, oh, they're the beneficiary because I had to have someone on there, and they don't split it with their siblings, there's nothing, you can't force them. It's theirs. So I think people don't think about that, or they forget. They forget they did it because they just wanted to throw somebody on there when they bought the policy, but they forget, that, gosh, that person's going to be able to keep it all. It's really important, like every few years, to look at everything you have, look at the beneficiaries. Yeah. Yes, Lisa?
Isn't there some liability for that person that's on that account too?
There is. So if there's a decent sized bank account, I can give you an example. I give this example all the time, and you may have heard it before, but I had a client several years ago who had an account at Kellogg Credit Union. He had $70,000 in his account, and that was all he had, basically. He had a checking account, and that was his little nest egg. That was what's going to get him through his retirement. That was it. And he had a couple daughters, and he had his daughters on his bank account. And they were listed as owners. They weren't listed as beneficiary. They were on the Kellogg accounts with him. He said, well, the credit union told me to put them on there. And I'm like, okay, so they're on. Well, one daughter's husband has an affair and with someone at work, and he ends up leaving her, and this nasty divorce ensues. And she is like heartbroken, right? She's so mad. She's very bitter. And I'm like, oh my God, did he ask for the account in the divorce because her name was on it? Like, and he's like, nope, that's not what happened. He didn't do that. He's a good guy. I'm like, he's not a good guy. He's not a good guy. He had an affair, but okay. So anyway, he's like, no, he didn't do that. And so I'm like, what happened? Well, my daughter kept coming back to court with all these frivolous hearings and motions because she was mad, right? She was just furious about, I basically supported you our whole life so you could get your degree and do your thing, and then you left me, and now I don't have anything. And so the judge said, if you bring one more frivolous motion, I'm going to order you to pay his attorney's fees. And she did, of course, and so they, got a judgment to get the attorney's fees, but she didn't have any money, so they just went through and looked at anything that had her name on it, and his account had her name on it, so they sucked $30,000 out of his little pot, his little nest egg. She doesn't have the money to pay him back. And so now his $70,000 is $40,000 in that account because of this crazy divorce that no one foresees these things. Like, no one's thinking, oh, because my daughter's on the account, I'm going to get money sucked out for her attorney's fees in the divorce, or his attorney's fees in the divorce, you have to be really, really careful. There's liability. Or if you have your kid on the account and they get in an accident and hurt somebody and get sued, they can take money out of your account. So being on the account makes you an owner, which means they can go after anything that your name is on. So be real careful about that. I don't mind people being beneficiaries, like on credit union accounts. I'm fine with that. But the reason people put people on their bank accounts is so that they can, write checks if they need them to, or go to the bank or handle things. But a power of attorney does that exact same thing. If you do a financial power of attorney and give a copy of it to the bank, they know that your kid can come in and take care of things for you without being on your account. So there are ways around it. Yes, ma'am. That's fine too. Like a POD is the same thing as a beneficiary, kind of. It's at a bank, it's pay on death, POD. Banks will let you do that too. But it doesn't allow them to be able to write checks or take care of things. So power of attorney, after you're gone, yeah, they can't. But if you needed them to, like if you trusted them enough, that you thought, gosh, if I'm in the hospital and I need someone to pay my bills, you could give them a power of attorney to be able to do that. Yeah, yes, sir. Well, not managed, no. Like we draft them and tell you what, how to get everything in them. And then after, then you guys manage them. You do your own thing. You can, go ahead. Oh, yeah. Yeah, I always tell my clients that, yeah, if something happens to you and your kids have a best friend who's a lawyer and they want to go to them to do the distribution or help them with that, absolutely. Or, you're perfectly fine, but your niece graduates from law school and this is what she decides to do and you want her to do amendments in the future, you paid for it. It's your document. You can go to anybody. Yeah. Yes, yes. Adding things or taking things out of, or, yeah, yeah. Yes, you are the trustee. Yes, you can do anything you want. You can sell property, buy property, you can. No, you just can do it all on your own. Sometimes you do need things from your lawyer, like when you sell property that's in your trust, sometimes they'll need something that's called, at closing, a certificate of trust, existence, and authority, which says the trust is still in existence, and I'm the trustee, and I have the authority to sell it. So we write those up and give them to the closing company, but just to show that the trust is good, but we do that all the time. But other than that, you don't even have to tell your lawyer when you're buying and selling things or transferring things. So when you go to closing, if you're paying cash for the lot next door, you just say at the title company, hey, I want it to be titled in the name of my trust, not me. Yeah. Now, sometimes if you have a mortgage, they will have you put it in your name because your trust doesn't have a credit score, but you do. So they want to put the house into your name, then you get the mortgage, and then after that's done, you can transfer it into your trust. Yes. It really depends on how bad she is. If she's been deemed incompetent, or the question was, I have a mother that has, I keep forgetting to repeat the question, sorry. I have a mother that has severe dementia, and she's never granted power of attorney to my sister or myself. What are our options? And my answer is, it depends on how severe her dementia is. Like if she still knows who you are, still knows, who she is, still knows that she has assets and she wants you guys to take care of them. There's criteria that you kind of have to go through to make sure she understands things. But if it's like she's already been deemed incompetent by a couple doctors, or if she just doesn't get any of that anymore, then she wouldn't be able to sign a new power of attorney because she's not competent enough to do it. So then at that point in time, if there are assets that are just in her name and you guys can't get access to them, then you'd have to go to court and become her conservator. There's a guardianship or conservatorship. There's the two different things you can get at the court. Guardianship is over someone's person, their health, their placement, things like that. Conservatorship is over their assets, their money. But, my mom has dementia as well. And she has really, really bad days, but then every now and then she has a really good day and she knows exactly what's going on. And we have to catch. She honestly is about 50-50, and so if I caught my mom on a good day, she could tell me everything. She could tell me everything. And if we catch her on a good day, we're allowed to have her sign a power of attorney. It's at that moment, if she understands what she's doing and she hasn't been deemed incompetent. If someone has a dementia diagnosis, it doesn't mean that they're necessarily incompetent until they are, right? So we try to give people as much autonomy and independence as we can for as long as we can, but then there becomes a point in time where it's just not feasible, and then you have to get the court involved and petition those things. Yeah. Can you guys, any other questions about, we just kind of went off onto some of the other things we're going to talk about, which is great. That's why I asked for questions, because I want to have you guys do what you want to do. But I'll go to the next one, which is, what is a living will? You guys have probably heard of a living will. It's also called a patient advocate designation or a durable power of attorney for healthcare. It's your healthcare power of attorney. When you go to the doctor's offices, sometimes they'll ask you if you have that done yet, or they'll give you a form, or they'll always give you the form that you sign for HIPAA release, who can get information for you. But this is different. This is, if two doctors certify that you can no longer make your own medical decision in the state of Michigan, then you can name a person to stand in your shoes and make a medical decision for you. That's our law here in Michigan. It's called a patient advocate designation, or a medical durable power of attorney, or a durable power of attorney for healthcare. So basically, it doesn't come into effect until two doctors certify that you can no longer make your own decision. And I give these examples all the time, but one of these examples is, gosh, I want to say I've been doing this for almost 20 years on my own, and probably about 15, 16 years ago, I had a lady call frantic from Florida, and she said, my dad is in the hospital at Oak Lawn. He needs a blood transfusion. My sister is named as first on the patient advocate form. She is married to a Jehovah's Witness, and she refuses to allow the blood transfusion. And she's not a Jehovah's Witness, so she won't do it. I'm in Florida. I'm a registered nurse. I'm trying to get back there so I can make sure he gets his blood transfusion. I don't know what to do. So I said, well, have your sister call me. The sister, I don't know these people. Sister called, and I said, hey, you can resign, and let your sister, take over. So she's calling the hospital frantic. The sister is trying to get on a plane to get back here. Sister agrees to resign, thank God, and they take her word for it that she is who she says she is on the document at Oak Lawn. They allow the blood transfusion. Sister gets there in time. They drive to my office in Battle Creek from Marshall when they released him to sign a new one in my parking lot, because he couldn't get out of the car to get into the house, into my office is a little house, to get into the house. And because they were so, he could have died just because of the person that he picked. And she thought, she didn't want to do something wrong against her religion. But she also, he's not a Jehovah's Witness, so it was like, it was hard. It's a hard thing. And when he made her, 20 years before, his #1 patient advocate, it was because she lived close and the other daughter was in Florida. And she wasn't married to the man who's a Jehovah's Witness at that time, so she wasn't practicing that faith. So it made sense at the time, but if you're not constantly looking and thinking about, at least every couple of years, looking at your documents, things like that happen, so just make sure that you name a person who would do what you want, what you want, not what they would want, but what you would want, at that time. And it's in Florida, they have like a living will or an advance directive law where you can write out what you want to happen and the doctor has to follow it. We don't have that in Michigan. We have the law where you pick somebody. So I always say, pick the person that you trust, and then keep an open dialogue with them, because as we get older, our wishes change, so just keep talking to people about what you would want to happen or not want to happen should you come to that point. The way I write mine for my clients is, like, for instance, my sister is listed first because I can't do that stuff. she's listed first, but my schedule is a little more flexible because I can make my own schedule, right? So when she has to go to doctor's appointments, I'm generally the one that takes her. But I'm listed second, but I write mine where the person that's listed second can act without that first person being available. But then when the first person shows up, they trump the second person. So it works out for us where Kelly's the ultimate decision maker, but I can help out taking her to appointments if I need to. So any other questions or any questions at all about the medical power of attorney? Yes. Yeah. So there's like, if you do a trust, when you have a trust, you also have to have a will, believe it or not. It's called a pour-over will, and it says everything goes to my trust. And the reason you do that is, like I mentioned, like the lot next door comes up for sale, and you decide to buy it from your neighbor for 10 grand, but you forget to put it into your trust. you know, the lot's worth like 30 grand, but the neighbor gave you a good deal, so this one little piece of property has to go through probate. But if you have a pour-over will, yes, the will take it through probate, but it will say it goes into the trust to be distributed the way the trust says, because it might not be what probate would want it to go. Like maybe you want it to go to your nephew, not to your kids. You know, like there might be a reason why it would be different in the trust. So everybody has a pour-over will. So a trust, a pour-over will, medical powers of attorney, and then durable financial powers of attorney. This is who can pay the bills on, you know, who can take care of things that are just in your name, you know, not in your trust name. And then the last document we usually have to do is a deed, at least one deed to put your house into your trust so it doesn't go through probate. And if you have more properties, there would be more deeds, but that's what you're looking at several documents when you do all of it. Yeah. Any other, yes? Yeah. Well, it depends on how it's listed. So if it's like a LLC, you can do an assignment of your LLC interests into the trust. If it's a corporation, you have to change your corporation paperwork to make the trust the owner instead of, or the shareholder instead of you. So there's different ways, it depends on it. But yeah, oftentimes we will put the business into the trust. Someone like me, you really can't do that because I have a professional limited liability company and my husband's not a lawyer. So he can't practice law and run my business if something should happen to me. So it's a little trickier depending on what your business is. Yeah, so you guys think of, yes? Okay, so the question was if a property were to go into probate, how would that affect a property? Well, so you have to pay the fees to get it through. So there's an inventory fee that the probate court charges for every asset that goes through. And each type of asset has its own percentage of inventory fee. And it's so convoluted, I can't tell you. Like real property is a certain amount, bank accounts are a certain amount. Like, I don't know. It's you know, it used to be rule of thumb is $100,000 house might be like $300, you know, but I'm sure it's more than that now. And that was years and years ago. But once it's in probate, if there's any creditors out there to the estate of the person that passed away. So if I died, I had one piece of property that wasn't in my trust, had to go through probate, but I had $60,000 in credit card debt. Well, those creditors could come after, if you sell that property, can come after and get paid before anybody else gets the money, okay? So if there's creditors out there and things go through probate, the creditors get paid before the family gets paid, okay? So it's important that, especially if people have creditor issues, that we don't have anything go through probate because that stuff does have to get paid off the top. Yes, ma'am? No, good questions. Keep going. How much? She's asking if a property goes through probate and it's worth $300,000. So when you inherit something, whether it be through probate or a trust, it's not a gift, it's an inheritance, and you get what's called a step-up in basis. Now, I'm not a tax attorney, I'm not a CPA, but you get something called a step-up in basis. So you get the property at the value it was on the date of death. Okay, so what that means is if the house, when they bought it, was worth $200,000, but by the time on the date of their death it was worth $300,000, then he gets it for the $300,000 value, so that if he goes to sell it, he doesn't have a capital gain between the $200,000 and $300,000. Once again, I know enough to be dangerous when it comes to tax, but that is, you know, there are some benefits to inheriting rather than gifting while you're alive. Yeah, that's one of them. Yeah. Any other questions? Yes. Yeah. Yes, and so I talk so fast, I apologize. The question is, medical power of attorney, is it synonymous with advance directive? And I did mention this earlier, but once again, I'm a fast talker, so you might not have heard it, but advance directives, they're common in states that have that law, like Florida, where you can write out what you want to happen, and then the doctor has to follow it. But and usually an advance directive will also have a spot where you can name the person you want to make these decisions. And if it does have that spot, then it works in Michigan as well, okay? As long as you name somebody in the document somewhere, then it works in Michigan, okay? Yeah, you're welcome. Any other questions right now? Yes. Hey. Good question. So the question was, when you go to do a trust or a power of attorney or these documents, what kind of documents do you need to bring or have available? And like when you call our office, and probably most attorneys' offices, they'll have a questionnaire that they send you in advance that asks you for the things that we need you to bring, and in a lot of it, if you fill out the questionnaire thoroughly, you don't even have to bring half the stuff that they ask for, as long as it's filled out. And so things like current estate planning documents, any deeds to any properties you have, any business paperwork if you own a business, so we know the name of that entity and the ownership, things like that. If you know like what your assets are and you could write, hey, yeah, my investments are this much, my bank accounts are this much, then you don't really have to bring your bank statements. But if you don't feel like writing it all out and just want to bring your bank statement, you can do that too. So those are the kind of things that we're looking for, because we need to see what the assets are in order to be able to better explain how to have your stuff set up. Yeah. Okay, so so her question was, when you have a trust, for instance, and when you had it written up, you're supposed to review it every like 3 to 5 years, is what I said. And then she said, when you first started it, you had $50,000 in this bank account, but now you have $100,000 in this bank account. Do we have to keep letting the attorney know that you have more money in the account, basically, right? We don't know. We don't. So, for instance, like, let's say that you're going to leave things to 5 different people. They're not all your kids. Maybe they're different people. I always tell people, do it in percentages. Don't do it in dollar amounts, because you don't know what you're going to have later, right? You might have less or more. So if you have 5 people and you want to give it to them equally, you do 20% to each person. So they would get 20% of 50,000, you know, when you started. Now they get 20% of 100,000. So if we set up percentages, you usually don't have to change the documents very often. And we really don't know. You could even change banks and it doesn't matter, as long as you're making sure that your bank is the owner of your trust is the owner of your bank account. Yeah. Anything? Oh, yeah. Yes, ma'am. Depends on the company. Again, sometimes they do set it up where it goes to kids, but usually they don't. And it usually is, you know, the spouse is always on there, and if the spouse has passed away and the surviving spouse never did anything to change it, then they'll usually write a check out to the estate of the second parent to die. The question was, if you have a life insurance policy, and the spouse the second spouse passed away and the first spouse who passed away was named as the beneficiary, and now there's nobody listed on the beneficiary, does it automatically go to the next people in line? And I said it depends on the entity. You know, some places they do. Very rarely. Usually, if there's no surviving beneficiary, then it would have to go through probate. So it depends on, yes. It just depends. The question was, do you only do those portions through probate, or do you have to do the whole estate? So if there are beneficiaries or joint owners on assets, then they don't have to go through probate ever, okay? If there's anything else that didn't have a joint owner or beneficiary, if one thing has to go through probate, then the rest of it does. For instance, like a car. So like cars don't generally have to go through probate. If you have everything else has a beneficiary or is in a trust or whatever, and you have a car, it automatically goes to next of kin if it's worth less than $60,000. Okay, you can just go down to the Secretary of State, take the death certificate, they'll title it over to the spouse or to the kids or whoever. But if you have one other thing that has to go through probate, then the car has to go through probate too. So, or anything with a title. You can. Yeah, if it costs more to hire somebody to help you do it, and it's like a $60 check, it's not worth it. You know, like it's just not worth it, you know, but yeah, if it's not much, I wouldn't worry about it. And it really depends too, because there are different types of probate. So for instance, if it's worth less than like, I think it's like 25 or 28,000, then there are these small estate forms they can do that go to next of kin. There are different things we can do if it's not that much. But it still might cost hourly rate with an attorney more than what it's worth. So it really depends on what it is. Yeah. Okay, there was another one. Yeah, the bank should have done it when she went in with her documents, because we give them this little homework sheet that says, take this to the bank and put it all in the trust. So if you're putting a savings account in, they definitely should have put the checking account in too, yeah. Yeah, the question was, my mom had a checking and a savings account all under one umbrella at the bank. The savings account was in the trust, but the checking account wasn't, which is weird, you know. So was somebody on that checking account? Oh. Yeah, no, just on with her, like a joint owner with her? Okay, yeah, they both should have been in the trust. The bank should have put them both in the trust, unless she said, I don't want my checking account in the trust, which makes no sense. You'd think if you were there doing it, they would assume that all your accounts would go in, but I don't know what happened. Sorry. Yeah. Okay, any other questions right now? All right, let's keep going. This is the big one. If I have to go into a nursing home, will I lose my house? So basically, nursing homes are super expensive, right? And if you need to go on Medicaid, because you can't afford a nursing home, because nursing homes are somewhere between $9,000 and $11,000 per month now to go live in a nursing home and have someone take care of you. Most people can't afford that for long, right? So the rules are, if you're a single person, you're allowed to have one house, one car, a prepaid funeral, a tiny bit of life insurance, like $1,500 or less, and then $2,000 in the bank. You can also have burial plots and a funeral. Oh, I already said funeral. That's it. That's all you can have. So it's hard because, like, if you go to the nursing home, your income, if say you get $1,700 from Social Security every month and that's it, your income is your copay, and then the state picks up the rest if you go on Medicaid. So there's no money left to pay the bills on the house. So yes, you can have a house, but nobody can pay for it. So there's just a lot of little things to think about when people have to go on Medicaid. So people get really scared because, okay, so this hypothetical person goes on Medicaid, keeps their house, can't really pay the bills, but maybe the family starts chipping in to pay the bills because they want to keep that house, but they don't do anything with it. Then the person passes away, the house is only in that person's name. The state can come back and collect from that house, it's called a state recovery, for what they've paid for care for that person. So if that house goes through probate, because it was just in that person's name, it's supposed to go down to their next of kin, but the state has a lien on it because they paid for so many months of care for the person that was in the nursing home. They get paid before the family gets anything, and that's called estate recovery. But there are really easy things that lawyers can do to make sure that doesn't happen. I don't know if you guys have ever heard of a ladybird deed. It's a deed that says, I own my house. I use it for single people, okay? Married couples, we can do other things, but for single people, I own my house, but upon my death, if I haven't sold it yet or anything, I want it to go to my kids, okay? And that avoids probate. It's still eligible for to be exempt from Medicaid because it's in my name for my lifetime. It's only upon my death that it goes to my kids, and it's the greatest tool in the world to avoid estate recovery if someone ends up in a nursing home. So if we have a single person who's going into a nursing home and they're competent and they can sign a new deed, or if they've already signed a power of attorney that allows us to do a ladybird deed, which we try to do really far in advance, then we can have the agent under the power of attorney sign a new ladybird deed so the house doesn't get collected after someone's gone by estate recovery from the state of Michigan. So it's really scary because people are so afraid that they have to sell their house, spend all their money down to $2,000. There are so many things that attorneys like me can do, people who do elder law. In Michigan, continuing education is not required for lawyers. I think we're the last state left that doesn't require continuing education for lawyers. But the Medicaid rules change quarterly. So there's very few attorneys who want to do the area of law that I do because you have to stay up on the law. And if it's not required, why keep going back to school, right? So there's very few of us that do this because these Medicaid rules are so tricky. But we have the little legal loopholes, the very, very legal loopholes that we can use to be able to protect people's assets so they don't have to spend everything down. There is a lot we can do to protect stuff should people need to go into the nursing home. Getting things done in advance, like those powers of attorney, are critical because it really helps. But if you don't, we still try to do everything we can to help. I mean, it's crazy that people who might have, like that poor guy with his $70,000 in the bank, right? That might be all they have plus their house and a car, and yet they have to spend everything down to $2,000 before anybody will kick in and help them. But then maybe they recover and they can go home and they don't have any money left. It's just hard. It's hard when you think about it because people have strokes, might have to be in the nursing home for 6 months to get well enough to go home. Medicare is only going to cover 100% of 20 days in the nursing home. Days 21 through 100, there's a copay that some insurances cover, some insurances don't. So you might be in for 3 months and get some coverage, but then if you have to stay in for 6 months and it's $11,000 a month, your money could be all gone. And then you have to go back home and have nothing. So it's tricky. There are things that we can do to try to help people. And we're all at this age where, helping our growing kids and helping our aging parents and trying to do everything we can to find the right rules or the right resources to help people. So just know that there are people out there who are knowledgeable and can help you figure it out, you know. Any questions about that estate recovery or if the houses and things like that? No? Okay. Well, the last part is, can't I just make my children co-owners of my house or other assets? We've already gone through a lot of this. So the guy with his daughter on the bank account losing 30 grand, people that get in the accidents and their kids, you know, get sued and they take money out. Another one is if they, like, okay, I'll give an example. My sister and I were gonna go on my mom's cottage with her after my dad died, so that if anything happened, it would come to us, whatever. And my sister's she really loves this cottage, right? And I have a feeling that if my mom ever wanted to sell it, she would say no. You know, she'd be like, no, I want to inherit this cottage. Stacy can get the house in town. I want the cottage, because she loves this cottage. And if you add your kid to it and they don't want to sell it, you can't sell it. And that you forget those things. You forget those things. Like I've had these kids who, when their dad dies, they think their mom doesn't know anything, and they're on the farm with their mom, and their mom needs to sell off some acres to be able to make ends meet, and the son refuses to let mom sell it because they're on it. It happens all the time. And so adding your kids to your property sounds like a great idea, but it's not a good idea for the liability reasons we already talked about, but also for you're losing your control over that asset if you add somebody else to it, you know? Some other reasons are tax consequences. If you add your kid to the property, just like deed it to them while they're alive, or just give it to them while they're alive, there could be I'm not going to tell you what those tax consequences are because I don't know, but I know there are tax consequences to doing that. You're uncapping property taxes. You're doing things that could mess stuff up. You're losing your step up in basis that we talked about earlier. Also, have you guys heard about that 5-year look back? If somebody goes into a nursing home, if you give things away within 5 years of going into the nursing home, it will disqualify you for Medicaid, and there's a penalty. So if you give, you know how the IRS says you can give so much away every year to your kids? I think it's up to like 18 or 19,000 now that you can give away per year. Well, you think you can do that and you're fine, but Medicaid doesn't care about that. Medicaid says you can't give anything away. So let's say you gave each of your kids 10 grand, and you have 5 kids, and your 50 grand's gone, and then you have to go into the nursing home and your kids can't pay it back to you to try to do something else with it. Until you pay $50,000 to the nursing home, you can't get on Medicaid. So you have to pay the same amount that you gave away. Yes, ma'am. Yeah, so the question was, when you go into a nursing home, you're allowed to have one house, one car, so if people have multiple houses, they're kind of SOL. And I said, yep, but hold on, yeah, go ahead, and then I can answer more of that. Go ahead, yeah. Nope. So he said if they're in the trust, you'd be safe. No, a trust does not protect from nursing home. A trust avoids probate, makes distribution easier after you're gone. You know, administration's a lot easier, but a living trust does not protect for nursing home. There are special trusts that we can do for Medicaid approval for married couples. So if, I know single people, it's hard, but there are still things that you can do. And I'll give you an example. That cottage we were talking about with my mom got dementia. We started seeing signs of it about 10 years ago, just little signs here and there. And we talked to her and we said, hey, do you think it'd be smart to transfer that house to Kelly and I while things are still pretty good? And she thought about it a little bit, and then she's like, yeah, we want to protect it, whatever. So we did a deed that transfers the house to my sister and I like 6 years ago. So we're over the 5 years. And it's just sitting in a drawer. You don't have to record it. It's just sitting in a drawer. So in case my mom ever has to go on Medicaid, we've gotten through the 5 years and we did it. Nobody really even knows. I don't know if my sister even knows she signed it. I just have it sitting in a drawer. So just in case, right? Yes. Mm-mm. Not for Medicaid purposes. Well, then you're dating it wrong. Yeah, no. Well, you could write it up after the fact and record it later. So the question was, it doesn't have to be recorded. So in Michigan, our law says a deed is legal the second it's signed. Okay? We record it so nobody else tries to record another deed before us, you know. But she said, well, can't somebody just write up a deed after the fact then? Well, they could, but you can also record a deed 3 years later. So like, for instance, our deed we wrote up 6 years ago, I could record it today and it'd still be legal, but the date would have been 3 years or 6 years ago. You can, because people will write up deeds, back in the day, people did this a lot, where they'd write up deeds to give it to their kids and they'd put it in a drawer and they'd say, recorded after I'm gone. Attorneys used to tell people to do that all the time, because it can be recorded whenever. It doesn't have to be recorded when it's signed. So yeah, I guess dishonest people could write up a deed after it's gone. It would take somebody to fight it to, make it go away. But, you have to remember too, Medicaid fraud's a big deal, and the state doesn't, the state doesn't take it lightly. So anybody who wants to try to do that kind of stuff, more power to them. I'm never gonna allow it in the application that I do, but people get caught for doing crazy things, like not reporting assets and stuff. It's just, I had a guy who I helped one of my very first Medicaid applications years and years ago, who I put the application in and thought everything was perfect. His wife's in the nursing home, and we got denied. And I'm like, oh, why did we get denied? And then they said there's an extra asset. There was a house in Albion. And I'm like, there's a house in Albion? I'm like, what's the house in Albion? He goes, oh, it's not worth anything. And I'm like, I don't even care if it's worth negative. We have to tell them about it. We have to tell them they can look up on their supercomputers, anything that's, recorded anywhere. Like, there's a house in Albion that you didn't tell me about. I'm like, over and over again, I was asking this guy, do you have everything on here? Is everything listed? Are you sure we've got it all? I'm asking him about utility trailers that they have a little permanent title. I'm asking him about everything. And there's a whole house in Albion he didn't tell me about. Like, those are the things that, we're gonna get denied if we're not honest, but we're also, like, if you're trying to hide things, they're gonna find it. They're gonna find it, so, yeah. I guess somebody could post-date or predate a deed, but it would be illegal. So I would hope they wouldn't do that. So, but that you can do that even if you record it, so, so anyway, having your kids on your assets, your bank accounts, your house, it's just, there's so many reasons not to do it. There's just so many reasons, whether it be liability purposes, Medicaid issues, having control of the assets. There are better ways to do it, whether it be through a ladybird deed that gets it to them after you're gone, or doing a trust, or having a power of attorney that allows them to pay bills and take care of things without having to be on the account. There's a lot better ways to be able to handle helping your loved one through the right documents rather than being liable and being on their accounts, so I think that's all I have. But if you guys, anybody else have any questions they want to ask in front of everybody, if not, I'll hang out for a little bit if you got some more private questions you want to ask me.
Thank you so much, Stacey.
You're
Thanks for
welcome,
coming in
Lisa.
today. Give Stacey